Hello guys, let's begin. So this video will start from here. Previous video we discussed that how or what are the three kinds of jurisdiction that Supreme Court exercises, right? The articles we saw, and each and every article of Constitution which is mentioned in your book and when you will go in class 12th. So whichever article is mentioned there also, you have to learn them all. So let's begin now. The President appoints the judges after consultation with judges of Supreme Court and High Courts of States. Now this you will learn in an elaborated form when you go in class 12th or in the upcoming unit of judiciary. Right now I will tell you a brief that President is the supreme authority to appoint the judges, to appoint the Chief Justice, let it be Chief Justice of a High Court or of the Supreme Court of India. So if the President has to appoint a judge of Supreme Court, then that has to be done with consultation of CJI and two judges of that Supreme Court. CJI plus two, okay? And if it is of High Court, then CJI, Chief Justice of that particular High Court, and another judge, right? So these are the recommendation committee that is formed while appointing a judge. Article 124 subclause 4 guarantees the President power to impeach the judge if a motion is passed by a special majority of each House of Parliament on the basis of proved misbehavior or incapacity to discharge one's duties. So there are two grounds on which a judge can be impeached. Everybody knows the meaning of impeachment. That means to remove the person from the rank which he has. So judges are not removed, they either get retired or they get impeached, okay? They are not removed like that, they are also removed by the same process by which a president can be removed, that is impeachment. Okay, remember this thing. And impeachment of a judge can be done on two grounds which are proved misbehavior, that it is proved कि इन्होंने इस पोस्ट में रहते हुए कोई गलत काम किया, which is not correct or which is lowering the potential or the honor of the post. अगर आप जज हो तो उस पोस्ट का, उस रैंक का एक ऑनर है, एक डिग्निटी है. आप कोई ऐसा काम कर रहे हैं जो उस पोस्ट को डिमीन कर रही है. सो दैट मीन्स प्रूव्ड मिसबिहेवियर. करप्शन कर रहे हैं. यू आर इन फेवर ऑफ अ पर्टिकुलर पार्टी जस्ट बिकॉज ही हैज़ गिवन यू अ सर्टेन अमाउंट ऑफ मनी. You have committed bribery and then you have delivered the verdict in favor of that person. So that is proved misbehavior. And if you are incapable to discharge the duties which you have to as per the post that you are granted, then that can be the two grounds on which by a special majority. See, impeachment के भी proceedings होती हैं in each house of the parliament. Discussions, debates होते हैं, vote किया जाता है कि इस जज को impeach करना है या नहीं, and if the special majority is achieved तो जज को impeach कर सकते हैं. And one thing more I will like to mention over here, that in India till now there is only one judge who is impeached. Name is Justice Soumitra Sen. Okay, I would write it over here so that it's easy. Further you will study in class 12th, nothing to worry about that. Soumitra Sen, Justice. And if you want an elaborated version of judiciary, then you can look up to the class 12th chapter 1 judiciary videos that are uploaded on my channel in the class 12th legal studies playlist. If you feel like you want to have an elaborated knowledge or extra knowledge, then you can look up to those videos. Otherwise, be as brief as you are required to as per this book. The Supreme Court of India has a special responsibility to render justice and enforce equality, liberty, dignity, and ideals of democracy, socialism, secularism, and such other values enshrined in the Constitution. Whichever values which are given in the constitution or in the preamble of the Constitution of India. These basically are the terms which are clearly mentioned in the preamble of the constitution itself. So Supreme Court has to interpret all the provisions or the principles which are there in the constitution or in the various rule books. It has to interpret and implement it so that it can deliver verdicts in the matters which are headed over to it, and it can deliver justice. Professor K.T. Shah, a member of Constituent Assembly, observed, "The judiciary is only authority that we are going to set up in Constitution to give effect to whatever hopes and aspirations, ambitions and desires we may have in making these laws and laying down this Constitution." That means, see, we have taken many things from the Britishers or from the East India Company that ruled over us for nearly 200 years time period. So there was a federal court at that time also that became Supreme Court later on, but then too judiciary is the only authority, is the only organ of government that is formally set up by the Constitution of India, because so that it can fulfill the aspirations, ambitions of the people, and it can resolve the disputes in an efficient manner to deliver justice to one and all. Also, even constitutional and legislative amendments are not immune from judicial challenges. That means every legislature action that it takes or any legislation that it frames out, that are subject to judicial review. They can be challenged in court. CAA, there are numerous examples that can be given in recent times or in historical context also, wherein various legislation actions or their laws framed by them that was challenged. In historic fundamental rights case, Supreme Court of India held that power to amend constitution was subject to the limitation that basic structure cannot be taken away. This means that even the sovereign power to change or alter constitution of India is subject to limitations. Everything has to come with certain restrictions or limitations, then only there will be smooth working. So any legislation, any amendment can be made with any part of Indian constitution, but the government authorities can't touch or can't disturb the basic structure of Indian constitution. Something which is so basic, right? The name itself, basic. कोई चीज़ इतनी basic है, अगर आप उसको disturb कर दोगे तो पूरा का पूरा structure हिल जाएगा. So similarly, basic structure के साथ आप कोई भी alteration, modification नहीं कर सकते. And if there is a legislation or a law which is framed that runs contrary to any of the principle or any of the provision which is a part of basic structure of Indian constitution, that being subject to judicial review can be taken up to the court and it can be challenged over there, and if the court feels like it is against the constitutional provisions, then that particular legislation can be termed as null and void and it will be no longer in force thereon. After the President's Rule case 1994, the basic structure doctrine was not just limited to challenges to constitutional validity, but was also extended to interpret the validity of exercise of power by legislature and executive. That means their powers were also restricted. High courts in various states are apex judicial bodies of the states. At the state level, highest court of law that you can approach to is High Court. There are currently 24 High Courts in India because those union territories or several states, they share the same High Court. That means a particular High Court can have jurisdiction over more than one state, and that may also include any of the union territory of India. 4 High Courts in northeast part of India having been established in March 2013. Bulk of work of High Courts consists of appeals from lower courts and writ petitions. See, as we have read, writ petitions can be entertained in Supreme Court by virtue of Article 32 and in High Court by virtue of Article 226. I'm telling this again and again. पता नहीं कितनी बार अभी तक मैं बोल चुकी हूँ यही line. सो हाई कोर्ट में जनरली जो मैटर्स आते हैं दैट आर एज एन अपीलिएट जुरिस्डिक्शन, हाई कोर्ट के पास भी अपीलिएट जुरिस्डिक्शन होती है। लोअर कोर्ट्स से एज एन अपील मैटर हाई कोर्ट में रेफ़र किए जा सकते हैं, और रिट पिटीशन के थ्रू फ्रेश केसेस भी हाई कोर्ट में फाइल किए जा सकते हैं। अपार्ट फ्रॉम दीज, एनी सिविल और क्रिमिनल केस विच डज नॉट फॉल विद इन द purview or ambit of subordinate courts of that state due to lack of pecuniary or territorial jurisdiction can be heard by the high court of that state. See, there are some courts which are set up on some basis, some to serve some purpose, right? कुछ लिमिट्स, जैसे कंज्यूमर फोरम्स हैं, तो उनकी कुछ लिमिट्स सेटअप की जाती हैं कि इस पर्टिकुलर कंज्यूमर फोरम है तो उनमें कुछ मॉनेटरी अमाउंट की लिमिट सेट की जाती है। अगर 1 करोड़ तक है तो स्टेट लेवल 20 करोड़, नेशनल लेवल, इस तरीके से, ठीक है। और अगर टेरिटोरियल जुरिस्डिक्शन है कि इलाहाबाद का एग्जांपल नहीं लूँगी क्योंकि यहीं पर हाई कोर्ट है। इफ़ देयर इज़ अ सिटी जहाँ पर सिर्फ डिस्ट्रिक्ट लेवल कोर्ट है, हाई कोर्ट नहीं है, लेकिन लाइक यू कैन से any small city which doesn't fall under the territory of a big city, but then too it can approach to the high court, क्योंकि वहाँ पर किसी भी डिस्ट्रिक्ट लेवल कोर्ट का इस्टेब्लिशमेंट नहीं है, तो आप फ्रेश केस हाई कोर्ट में डायरेक्टली फाइल कर सकते हैं। अपार्ट फ्रॉम द रिट पिटिशंस भी फ्रेश केसेस हाई कोर्ट में फाइल किए जा सकते हैं। Also, certain other matters or issues may be heard by High Court as part of its original jurisdiction if law laid down by legislature provides to that effect. That means, see, again, High Court has appellate jurisdiction, High Court has original jurisdiction, means it can deal with the matters, let it be civil or criminal or anything, that are directly or fresh cases that are directly filed into the High Court. For example, company law cases fall within the original jurisdiction of High Court. That is depending upon the various laws that are providing the pass, or that is expanding the arena of or the jurisdiction of High Court. Next is legal profession in India. History of legal profession can be traced to the establishment of first British court in Bombay in 1672 by Governor Ongia. Now see, legal profession means people who saw this field as a part of doing some job, right? That is profession. Admission of attorneys was placed in hands of governor in council and not with court. Prior to establishment of mayors courts in 1726 in Madras and Calcutta, there were no legal practitioners. कोई भी legal practice नहीं करता था इंडिया में, but after the mayor courts were established way back in 1726 in 2 presidencies of Madras and Calcutta, तो उसके बाद कोई लीगल प्रैक्टिशनर्स आना शुरू हुए, कुछ लोग आना शुरू हुए जो लीगल को प्रैक्टिस कर रहे, लाइक एडवोकेट्स और वकील्स और लॉयर्स, बैरिस्टर्स, वॉट एवर यू मे टर्म दैट. So that happened after 1726 to an effect. During the shift from Mughal legal system, advocates under that regimen, vakils too followed suit, although they mostly continued their earlier role as client representatives. There are certain clients, so मेरे client ये हैं, that means you are representing that person, because the person doesn't has an elaborated or a sufficient knowledge of legal as a field कि वो केस लड़ सके, तो वो आपको एक रिप्रेजेंटेटिव अपॉइंट कर रहे हैं कि आप मेरे लिए केस लड़िए, राइट? यू रिप्रेजेंट मी इन द कोर्ट, है ना? सो क्लाइंट्स, सो एज क्लाइंट रिप्रेजेंटेटिव वकील या एडवोकेट्स होते थे इन द मुगल लीगल सिस्टम. Doors of newly created Supreme Courts under British were barred to Indian practitioners that we saw. For Indians, there were no jobs available in the Supreme Courts. Supreme Courts were set up not only in Delhi but in those 3 presidencies also. उसके बाद गवर्नमेंट ऑफ इंडिया एक्ट 1935 के थ्रू एक फेडरल कोर्ट दिल्ली में इस्टेब्लिश हुआ था, बट उसके पहले सुप्रीम कोर्ट्स थे इंडिया में. अगर आपको कुछ भी पढ़ा हुआ याद हो तो, अगर नहीं याद है, you can look up to the previous videos. You can watch them again and again until the concepts are clear to you. Newly created Supreme Courts में Indians के लिए कोई job available नहीं थी, as right of audience was limited to members of English, Irish and Scottish professional bodies. That means English, Irish and Scottish people could only follow it. However, enactment of Legal Practitioners Act of 1846 opened up the profession regardless of nationality or religion. So we are literally, or the people of that time may be literally thankful to this act of which was passed in 1846, that allowed the person, regardless of whichever religion or region or nation he belongs to, वो लीगल को प्रैक्टिस, लीगल एज अ प्रोफेशन प्रैक्टिस कर सकता है, वो एडवोकेट बन सकता है. Advocates Act 1961 is another. Now see, this 1846 is something which is pre-independent era, and Advocates Act 1961 is post-independent era. Governs the legal profession in India. It is very important if you are studying legally, and if you if you also go further to pursue this as a profession, then it is important that you must know which act, when was it passed, that governs the legal profession of and in India, that is the Advocates Act of 1961. Under this, only advocates enrolled in India with a state bar council are entitled to practice the profession of law. If you are a student of a particular school, of a particular class, you are enrolled in the attendance list, you are enrolled in that class. Similarly, if you are willing to practice legal profession, if you want to become a lawyer, then you have to enroll yourself after getting a certain degree of LLB or BLLB or BBA LLB, whatever you may want to pursue. कुछ भी आप ले सकते हैं. एक सर्टेन डिग्री के बाद यू गेट एनरोल्ड विद अ स्टेट बार काउंसिल, यूपी बार काउंसिल हो या इंडिया बार काउंसिल हो या किसी भी स्टेट की बार काउंसिल हो, उससे आप एनरोल किए जाते हो. एंड आफ्टर दैट ओनली यू कैन प्रैक्टिस इट. आप सोकर उठे और कोर्ट चले गए, आज हम लॉयर बनेंगे, ऐसा नहीं. व्हेन यू गेट अ डिग्री, व्हेन यू कंप्लीट अ पर्टिकुलर कोर्स, देन यू गेट एनरोल्ड विद अ स्टेट बार काउंसिल, एंड देन यू कैन pursue this profession as a and then you can pursue this legal profession, which includes not only appearing before courts and giving legal advice as an attorney, but also drafting legal documents, advising clients or international standards, and carrying out customary practices and transactions. If I tell you, in today's date, each and every organization has a legal advisor post in its place. हर ऑर्गेनाइजेशन में, हर इंस्टीट्यूट में आज की डेट में एक पोस्ट है, एक रैंक है लीगल एडवाइज़र के लिए, जो उनको लीगल मैटर्स में एडवाइस करे, सजेस्ट करे. सी, लीगल एडवाइस इंपॉर्टेंट है ना. हर बंदा तो लॉ को नहीं पढ़ता एज फ्लुएंटली या एज एफिशिएंटली. आप पढ़ेंगे, अगर आप लॉ की डिग्री को परस्यू करते हैं, तो हमें नॉलेज नहीं है. बीएससी जो कर रहा है उसको एलएलबी की नॉलेज नहीं होगी, उसको लॉ की इतनी नॉलेज नहीं होगी, and vice versa, that is also true. So similarly, जैसा मैंने बोला, हर इंस्टीट्यूट में आज एक लीगल एडवाइज़र है. तो किस तरीके से, अगर आपके इंस्टीट्यूशन पे किसी ने केस किया, आपको किस तरीके से डॉक्यूमेंट बनाने हैं या आपको कैसे रिएक्ट करना है ऐसे सिचुएशन में, एज़ पर लॉ यू हैव टू वर्क, कि कोई चीज़ आपके अगेंस्ट ही ना हो जाए. सो दैट इज़ व्हाट अ लीगल एडवाइज़र कैन हेल्प यू इन. The Advocates Act distinguishes between two types of advocates: senior advocates and advocates. Now, advocates is some people who work under those government or senior advocates. Senior advocate is designated by Supreme Court or any high court based on his ability or special knowledge in an area of law. Senior judges जो होते हैं, जो senior advocates होते हैं, that they are designated by Supreme Court. Like you may have heard of the names of Ram Jethmalani and Kapil Sibal. These are all senior advocates. ठीक है. So senior advocates, because of their experience, their ability, or the special knowledge with which they contain in any special field of law, they are designated as a senior advocate of a particular high court or the Supreme Court. A senior advocate cannot file वकालतनामा before any court or tribunal in India, क्योंकि उसकी पोस्ट बड़ी है. However, in order to file an appearance before Supreme Court, one must be an advocate on record or be instructed by an advocate on record. On record, you first of all you need to be enrolled. If you have to go into the court, you have to be enrolled with the State Bar Council or with the Indian Bar Council. Next, that you have to be an advocate on record. उस कोर्ट में आपका नाम रिकॉर्ड में होना चाहिए कि हाँ ये बंदा हमारे कोर्ट में एज एन एडवोकेट सर्व कर रहा है. अगर आप एडवोकेट ऑन रिकॉर्ड में नहीं हैं तो कोई सीनियर एडवोकेट द्वारा सजेस्ट किया गया, आप अगर किसी सीनियर एडवोकेट ने बोला कि आज सीनियर एडवोकेट हैं, तो मैं बताती हूँ जो जनरली होता है उनके अंडर 2-3 एडवोकेट्स प्रैक्टिस कर रहे होते हैं, तो वो उन जूनियर एडवोकेट्स को जो कि उनके अंडर प्रैक्टिस कर रहे हैं उनको भेज सकते हैं अपने बिहाफ में केस लड़ने के लिए. ठीक है, सो दैट इज़ नोन एज इंस्ट्रक्टेड बाय एन एडवोकेट ऑन रिकॉर्ड. To be eligible to qualify as an advocate on record, a 1-year training contract with an advocate on record needs to be completed besides passing prescribed test. एक एक्सपीरियंस होना चाहिए 1 ईयर का कि आप उस बंदे के साथ काम कर रहे हैं जो कि एक एडवोकेट ऑन रिकॉर्ड था. At federal level, Bar Council of India performs oversight functions and lays down standards of professional conduct, recognizes universities whose degrees qualify for enrollment, etc. Typically, each state has its own bar council which regulates the admission and removal of names of advocates from its rolls. कोई एडवोकेट है जो कि वो प्रोफेशन छोड़ के कोई और प्रोफेशन अपना गया तो वहाँ से उसका नाम स्ट्रक ऑफ कर दिया जाएगा. ठीक है, और अगर देयर इज़ अ न्यू पर्सन हु इज़ ग्रेजुएटेड एंड हु बिकम्स एन एडवोकेट तो उसका नाम ऐड किया जाएगा उस लिस्ट में. ऐसे ये मॉडिफिकेशंस होती रहती हैं. Then there is as I told you, there is Bar Council of India, and in each state also there is a Bar Council. So you have to be registered with either one of it. Bar Council of India approved कुछ colleges या universities होती हैं जिनकी जो लॉ की डिग्रीज होती हैं उनको वेरीफाई किया जाता है. इफ़ इट इज़ क्वालिफाइड और इफ़ इट इज़ रिकग्नाइज्ड बाय द बार काउंसिल ऑफ इंडिया देन ओनली आपकी डिग्री को भी आगे जाकर रिकग्नाइज किया जाएगा. Enrollment with the State Bar Council as an advocate renders a lawyer eligible to practice before all courts and tribunals in India. किसी भी एक स्टेट बार काउंसिल में अगर आप रजिस्टर हो गए, उसमें आपका नाम लिस्ट में आ गया, then you can practice as a lawyer in any and all court of India. Obtaining a BA LLB or LLB degree followed by passing of bar exam will qualify a person for enrollment. So you have to give a test and then you have to complete this 1-year training contract. The bar examination was introduced in 2010. In order to be eligible for enrollment, a student should also have completed his or her studies in one of the institutions recognized by Bar Council of India. As I told you, Bar Council of India ने जो institutions recognize किए हैं उसमें से आपको उस डिग्री को complete करना ज़रूरी है ताकि वो जाकर आगे verify हो सके. The dual system of classification between solicitors and attorneys was abolished in 1970. As we read, पहले एक टर्म अटॉर्नी आया था तो सॉलिटर और अटॉर्नी के बीच में डिस्टिंक्शन ख़त्म हो गई in 1970. But Bombay Incorporated Law Society still conducts examinations for persons who wish to qualify as solicitors upon completion of a 3-year training period in a solicitor's office as an article clerk and passing of a solicitor's exam. आजकल हर जगह एग्ज़ाम हो रहा है, so you have to pass that, or that person needs to pass a solicitor's exam. He has to complete 3 years training and then he can be termed as, or he can also get the rank or title of a solicitor. Now careers in law I'm not gonna read. You can go through it if you want. I don't think so such things will be asked in your examinations, but then again it depends upon school to school. Next video we will be starting with unit 3 chapter 3.